Good morning. Today is Tuesday. It's the 26th of August, and it's Criminal Day. We're going to start our morning with our misdemeanor arraignments. We have quite a few of those. We have some pre-trials also. I didn't look to see how many of those there were. City Three Rivers Day and White Pigeon Day. Then we'll be doing for the first time ever, or at least in a long time, our sobriety court in the morning because I have an obligation to be in Kalamazoo County this afternoon on a case I've been assigned. So we'll be on the record here probably until about 10 o'clock. Then we'll go off the record for sobriety court. Then I'm going to go to Kalamazoo. Then I'll be gone for a couple of days and we'll be up with a full docket on Friday. We had a full busy day yesterday. We were on the bench basically from 8 to 12 and 1 to 4:30, but we did finish everything. It is a sunny, cool day. It was cold and dark to ride my bike this morning, 53 degrees, but that's not too bad, all things considered. Our visitors are still here. We have one customer here so far on a show cause, and should be pretty smooth sailing this morning. It's been a beautiful couple of sunny days, if not cool. Feels like autumn here, probably where you are too. Autumn would be really good. It was followed by spring, and we could enjoy it all the more. But it's followed by winter. We got a full gallery. Might as well just get to work here. We're having a good day so far. Tippy Bingman is here, making sure we got everything in order. Good morning, everybody. I'm Judge Middleton. This is a court we might get to use. You're here for an arraignment. The arraignment is the process where the judge tells you what you're charged with and asks you how you wish to plead to the charge. I'll explain a little bit as we go further in the process. This gentleman over here on my left is the Chief Public Defender for St. Joe County. And he is here to make sure we follow proper procedures and make sure that your rights are protected as a defendant in a criminal case. When I call your name, I want you to come right up here to the podium, and then we'll call the case number, and then we'll talk about your case. First one we're going to do, he gets the prize for being the first person here, is David Scott Havens. Mr. Havens, would you come forward, please? This is file number 241920. This is a show cause. Mr. Havens was charged with a retail fraud second, reduced to a retail fraud third, plus paying, then was going to continue to pay. And I don't think we've had any payment since May. They set a show cause hearing for him to come in earlier in August. They didn't come in. I didn't want to do a warrant for him, so I did a show cause just to check up on how we're doing here. And he is here this morning. Good morning, Mr. Havens.
Good morning, Your Honor.
You look good.
Well, thank you, sir.
You were having some health struggles, but right now you look pretty good.
Yeah, the doctor's got me on a diet, need a hip replacement. Got to get there. And I'd like to apologize. My last appearance, I had received your letter, and it was set for the 6th. For some odd reason, I circled the 8th, and I was watching the YouTube, and you called my name, and I nearly fell on the floor. I called right away, spoke to Laura, and she gave me this date today, sir.
All right. Are you able to make any payment on this?
Sir, if you give me about one more week, I got something happening, and I'll be able to take care of it.
How much is left due? I can't
It
tell.
was originally 380. It's down to 180.
All right. So you'd like to just pay the rest of it off? 830. Defendant intends to pay out balance off before that. All right, then I'll get off your back. Are you still at apartment 1?
Yeah, one.
Yeah, I didn't want to put your address on there, but all right.
Yeah.
All right, you're good to go.
Thank you, sir. You have a wonderful day.
All right. And if you pay it, well, I won't even have to see you anymore. So very good.
Thank you.
All right, that's a show cause. He's been very conscientious about paying us stuff. We had a clerk here this summer that helped us try to get caught up on our delinquent accounts. The rest of you are here just for an arraignment on a criminal charge. We've got a few people that have not shown up. But let's start with Rodney Bowman. Good morning, sir. Are you Rodney Allen Bowman?
Yes, sir.
Mr. Bowman, you got a ticket in Three Rivers on August 4th for driving with a suspended license and failing I guess that was in Sturgis. Let's take a look at
Yes,
this.
sir.
This is Three Rivers Day. I'm not sure why we got a Sturgis case on here, but let's take a look. Hopefully the city attorney will join us in a minute. I talked to Mr. Reed yesterday afternoon and he said he'd see me this morning. You got a ticket at Centerville Road and Enterprise in the city of Sturgis for failing to yield and driving suspended. Leaving the parking lot when he failed to yield and collided with another vehicle. Knew he didn't have a license to drive. Driving suspended is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. Carries 2 points on your driving record and it requires that your license be suspended. Why don't you have a seat for a minute and we'll see whether the village attorney or the city attorney is going to be here with us. So we'll come back to this before I ask what you want to do. 8:26. I don't move too fast, but I do keep moving. Next person to check in was Tanya Moeller. Come forward, please. Now, this is an old case. Good morning. Are you Tanya Marie Moeller?
Correct, I am.
All right. The file number here is 23878SM. You were charged with larceny under $200 for stealing some money from a man. I think it was cash money. You were put on probation and then we just sort of lost track of you. You failed to appear for your probation violation arraignment and there's been a warrant out for your arrest for some time. You contacted the court and made arrangements to come in and deal with this. So let's go back to your probation officer, Autumn Kiefer, filed a probation violation petition in June of 2024, alleging that you failed to report on a monthly basis. You were put on probation in January of 24 for larceny. And then we sort of lost track of you probably in about March. Let me take a look. So she filed that petition in June. You didn't show up. I only put you on probation for 6 months. We lost track of you in April. Part of the issue was you wanted to continue to use marijuana, and then also the issue was there was restitution, and I don't believe you ever made any payment on this. So you didn't show up. We issued a bench warrant in July of 2024. I tried to call you. I left a message on your voicemail, and I set the bond at $2,000 cash or surety. That was in July of 2024. Then we sent you some notices to pay. You owed $565. Some of that was restitution. Then you got arrested on August 6th and posted a bond, but it was through a bonding company. So when it comes to getting out of jail, people often come up with a bond. So here's the deal. This is essentially a probation violation arraignment. You were placed on probation. As a condition of probation, you were to pay costs, restitution, and report to your probation officer. You failed to report. She filed a petition for a probation violation. I set it for a hearing. You didn't show up for the hearing. I called you up on the telephone, left a message on your voicemail and said, hey, please get in here. Well, you didn't. How did you get stopped on August 6th?
I've been in Bay City since July of 2024, taking care of my mom. And I was coming down here to actually deal with all this when I got pulled over on I-69.
What county were you in?
Calhoun.
All right, so they took you to jail in Calhoun or they brought you here?
They took me to Calhoun. I sat 3 days in Calhoun County. My mom bonded me out due to needing my care.
Why'd they pull you over in Calhoun County?
I ran out of gas on I-69. They really didn't pull me over.
Okay, so you didn't get a
I was
traffic.
just sitting there, and when she read, and that's when I found out I had the warrant.
Do you still live on Schuneman Road?
Yes.
All right. Well, the bad news is you got picked up. The good news is we're finally gonna address this.
Correct.
All right, now normally on a probation violation, I would tell you that you're subject to a violation of probation. You're entitled to have a hearing regarding that, where it has to be proven beyond a preponderance that you violated the terms of your probation. You'd have a right to have an attorney at that hearing. I think you pled guilty to this without an attorney, but if we set a probation violation hearing, we would appoint a lawyer for you. And that's what I would actually recommend. I don't know what your current status is because I haven't seen you in a year or more. Your probation agent recommended revoking your probation and imposing 5 days of jail. One concern I had is I still like to have this man get his restitution back for the $180 you took. As far as I can tell, I don't think he ever paid anything. So he never got his money. You never did any of the stuff you were supposed to do on probation. I hung 20 days over your head. Anyway, you drove all the way down here from Bay City today, which I appreciate. But what I would recommend is that you plead not guilty and I get a lawyer to help you with this. And we check in with your probation agent, find out what your current status is. Is that agreeable?
Agreed.
Appoint an attorney, set a PV hearing. Now, this isn't going to be very hard to prove. The allegation is you failed to report. Well, we haven't seen you in a year. So, and you haven't paid 1 cent. So those things won't be very hard to prove. The question is, what do we do? You've already done 3 days, but I did hang 20 days over your head. This was a pretty unsuccessful probation. So what I'd like you to do is go out to the counter. They're going to appoint an attorney for you and give you a date to appear. Then I want you to go downstairs and see Autumn, your probation officer. Did you get my message? I left a message on your answering machine.
I haven't had that number for probably since July of 2024.
All right. Well, we'll get the case back on track. One big issue is I'd like to get this man's restitution paid.
I'm working on that, Your Honor, with the care for my mom and my stepdad. It kind of enables me.
Well, the money they used to bond you out of jail and paid to a bonding company could have been used to pay restitution to this guy. That we don't get that money back. It goes to the bonding company.
Exactly.
So that could have been, I think it was probably at least $200.
It was, Your Honor.
All right. Well, that money's gone and we don't get to use it for fines or restitution. You go with a court officer, then I want you to go downstairs and see Autumn Kiefer before you leave. We'll get current contact information and update as to your status. All right, you're good to go. And we're still plodding along, but we are plodding. Henrik Payne. Good morning, sir.
Good morning.
Am I saying that right?
Henrik? Yes, sir.
Henrik Robert Payne.
Yes, sir.
Mr. Payne, you got a ticket. In Three Rivers for operating while intoxicated on August 9th. Charged as a first offense. Your blood alcohol is 0.17. I guess they could have charged high blood alcohol level, but they charged it as plain old operating while intoxicated.
Yes, sir.
Operating while intoxicated is one of our most common offenses. We had 160 or so last year. It's punishable by up to 93 days in jail and a fine of up to $500. Carries 6 points on your driving record and requires that your license be suspended. Normally, what I would recommend is that we get an attorney to help you with this.
Okay.
Set it for further pretrial.
Okay.
Is that agreeable with you?
Yes, sir.
What do you do, sir?
Construction.
For who?
Duluth construction.
What do they do?
Commercial construction. Well, and residential, but mainly commercial.
Who are you here on behalf of?
I'm sorry,
Who are you here for?
Ms. Hornbaum?
Okay. We'll take that up in a minute.
Okay, thank you.
Which Payne are you? Who's your parents?
Robert and Lynn.
Okay.
You probably don't know either one of them. Never
I
been in
think I know
trouble.
Robert Payne.
Oh, you do know I did? Okay.
Plead not guilty. Appointed attorney. And set attorney pretrial. For, I hate to say this, October 3rd. Summer's gone at 8:30. So here's the deal. The court officer, did he get printed?
Yes, sir. Yes,
All
sir. I got the paper right here.
All right, very good. This is a sore point. Everybody, as far as I'm concerned, that gets arrested and goes to jail are supposed to be fingerprinted at the jail.
Okay.
But for reasons I have never quite fully understood, they don't do it. So we got our own fingerprint scan machine here at the courthouse, and our bailiffs regularly scan people to make sure that we've got them in the system. My concern would be, particularly with the way identification is and people that don't have lawful, that they get arrested, they get out of jail, we never fingerprinted them to make sure who we had.
Mm.
But the sheriff's got their own reasons for doing it, but I don't like when people don't get printed at the jail. Anyway, he's gonna take you out. You're going to get some paperwork with your lawyer's name and number on it.
Yes, sir.
I want you to call that lawyer, make an appointment to discuss the case with them.
Okay.
And that will be at 8:30 in the morning. They'll get the police report, lab reports,
Okay.
video camera, any of that kind of stuff. Have an opportunity to go over it with you before the pretrial.
Perfect.
And at that point, we can see if the case can be resolved with a plea, and if it can, it can be set for trial.
Okay. Thank you, sir.
Okay, thank you. Laura, Shayna, anybody, do you know where the city attorney is? I haven't seen Mr. Reed or Mr. George on behalf of the city of Three Rivers or Sturgis.
Mr. George is gonna be a little busy today.
Is Tim here? Well, I've got at least one case I could use some help from him, or probably more. Here's Mr. Reed right now.
Is it okay if I change the lock on the camera?
Oh, what did I do?
Yeah. Well, I had Mr. Bowman here, and I'm about to have some others.
Okay.
I got a couple of retail frauds that I think might be civil infractions, and here's one right now. This well-dressed gentleman is Mr. Timothy Reed. He's the city attorney for Three Rivers and Sturgis. We're going to talk to Daisy Celeste Burkheiser. Good morning.
Good morning. Sorry I was late. I also was getting fingerprinted.
Okay, well, you're here in plenty of time. Ms. Burkheiser, you got charged with retail fraud in Three Rivers. You posted $100 of bond. Retail fraud is a misdemeanor generally in the state of Michigan. It's a little different when it's charged under ordinance. It's punishable by up to 90 days in jail and a fine of up to $500. This one doesn't require that you get fingerprinted. It's a 90-day offense rather than a 93-day. It's alleged that you were at the Walmart store and you took allegedly $49.94. And there was a video of this. Anyway, that's the allegation. Three Rivers, unlike state law, also has a civil infraction version of retail fraud. A civil infraction is not a fine. It's like a speeding ticket or running a stop sign. Mr. Reed indicated he would agree to dismiss the misdemeanor charge if you pled to a civil infraction. Posted $100 of bond, the fine is $100. I would take your bond money, pay your fine, and you would be free to go. Are you willing to admit to the civil infraction?
Yes, Your Honor. Thank you.
Well, you can thank Mr. Reed in the city of Three Rivers.
Thank you.
Anybody threaten you to get you to plead to this
No, Your Honor.
or promise you anything?
No, Your Honor.
I don't have any advice or rights from anybody, but this will be a civil infraction. Did they give you an advice or rights sheet?
Yes.
Okay, we'll get that before you go. Were you in the Walmart store on this day, which was November 24th, way last year?
Maybe. I don't
All right.
remember.
Morning, sir. Could you take your hat off? How are you doing? You're not set for me today, are you? Oh, just visiting? All right, well, good morning. Anyway, it said that some tags got swapped for some pajamas, a Barbie jacket, and a women's jacket, and the total was $49.94. Do you acknowledge that?
No,
All right, what happened?
I am not sure.
Here's what it says. Ashley said that Daisy Burkheiser swapped tags on some clothing with the tags of cheaper clothing, a rib cami, which is similar to a tank top. Daisy then scanned and purchased the clothing items using these swap tags. Ashley said she was informed about this by another employee who noticed Daisy's receipt did not match the items she purchased. Ashley reviewed the video surveillance footage to confirm this, then got Daisy's information from the card she used to purchase the goods. So they ended up, you didn't even see the police that day.
Correct.
All right, they turned it over to the police. They watched the video. They allegedly see you switching the tags and then leaving with the merchandise. And the police submitted this for a warrant, and they got a warrant for your arrest. And then you got arrested sometime
I
recently.
turned myself in once I found out about the warrant.
All right. So that's the allegation that some tags were swapped. Do you admit to that for purposes of the civil infraction?
Yes, I do.
All right. I'm going to call your case next if you're ready.
Sure.
Okay. All right. Swap tag. So it's admits to civil infraction. My handwriting is so bad I can't even read it. All right. Fine and cost. Fine is $100. You got $100 of bond. Apparently you walked out with $49.94 worth of fine and cost is $100. Restitution to Walmart, like they need it, of $50. Total fine and cost $150. apply $100 of bond. Go $50. Can you pay that within 30 days?
Yep.
We'll make it due by end of the September 30th. I'm sure you'll pay it.
Am I able to pay that here or will it not be available?
Yeah, you can pay it right now if you want to. You're
Yep,
just
I
gonna
can do
pay
that.
it now?
Mhm.
All right. All right, Ms. Burkheiser, I'll send you over to the court officer. This is not a crime. It's not gonna show as a criminal conviction on your record. It's a civil infraction. You admitted the infraction. I used your bond to pay most of it. You're gonna pay Walmart for the property that was taken, and you're good to go.
Thank
All
you.
right, thank you. All right, got Amanda Sue Heimbaugh here with counsel from the Hutchins Law Office.
Good morning, Your Honor.
Good morning. Nice to meet you. Could you put your appearance on the record?
Sure, Your Honor. I'm Zoe Hutchins on behalf of Amanda Heinbach, who's present and standing to my left.
You're from Paw Paw?
Originally, my office just moved to Kalamazoo.
All right. Um, are you Amanda Sue Heimbaugh?
Yes, Your Honor.
Well, the Heimbaugh name is a very old St. Joseph County name. Heimbaugh Road is named after the Heimbaugh family. It is the shortest point between M60 and 131. So semis like to drive down there. The Heimbaugh home, which was a fine home in its day, was a brick, very nice house that fell into dilapidation. Henry Heimbaugh was the last member of that family, and he lived into his 90s. And the house was in terrible disrepair. He died, and they tore the house down, and now it's just a flat farm field. But probably told you more than you want to know about the Heimbaugh family. But and it's spelled two different ways. In St. Joe County, it's spelled this way. And sometimes they spell it another way. Anyway, Miss Heimbaugh, let's talk about your case. I saw you check in with Mr. Reed. This is charged as a second offense, so it's a 1-year misdemeanor charged under state statute. And he doesn't have jurisdiction over those. That isn't to say that something could be worked out where it could turn into a city offense. But right now, it's a misdemeanor charged by up to a year in jail. I'm trying to find your case. And a fine of up to $1,000. Requires that you be fingerprinted.
She was.
Sometimes it's me, and sometimes the case isn't in here. This case isn't in here. I should have caught that earlier. No, I'm not crazy. It's not in my queue. Well, I might be crazy, but I'm not crazy for that reason. It isn't in my queue. 24-851. All right, this is another one like the last one that happened some time ago, and then it took a while to get arrested and get here. I'm sure you're gonna plead not guilty and we're gonna set a pretrial, but let me tell you what the allegation is. It's alleged that between November 1st of 23 and March 31st of 24, that you did alter, remove, transfer, replace, or conceal, otherwise misrepresent the price at which property was for sale. More than $200, but less than $1,000. The allegation is you took $233.31 worth of stuff. No, this is a wide range. They tracked your card. They call it skip scanning, and I don't like the whole thing. If they had real live cashiers, this wouldn't even be a thing, but they allege that on 6 occasions you skip scanned items and they didn't catch you until the 7th incident, which was caught live. Heimbach fails to scan items or she'll put 2 items together and scan them as one. All 7 incidents of the theft total $233.31. Walmart has video footage of each incident downloaded and available. Walmart employees say Heimbach's husband is also observing failing to pay for items, but I don't see that he got charged with anything. Anyway, those are the allegations. There's allegedly video of this and reports, and certainly your lawyer is going to want to get access to all that and review it. So, Ms. Hutchins, at this point, she just wishes to plead not guilty.
That's correct, Your Honor. And I believe she already posted $100 interim bond.
That's what it looks like. How did you get arrested on this?
I was pulled over for swerving to miss a turtle in the road.
Was it a Heimbach road?
No, Your Honor.
What road was it on?
Savison Road on the way to Shipshewana, Your Honor.
All right. Plead not guilty. Set an attorney pretrial for October 5th would be when we would do that. That's a Friday, the first Friday in October at 8:30. Would that work for you?
That one.
What's your P number?
P70717.
And I'll ask you to file an appearance. As I indicated, Mr. Reed doesn't have authority over this. The county prosecutor does. There's apparently 7 video episodes and perhaps other stuff. You'll want to get access to that.
I believe we've already filed an appearance.
All right. Hasn't made it to the file yet, but yes, it does. Hutchins Law. It's here. All right, what I would suggest is at least touch base with the prosecutor's office, get access to the reports, and your bond is continued.
Thank you. Your Honor.
Did you go to jail for this, or they lay a post bond on the side of the road?
I had to go to the jail to post bond, Your Honor,
Did you spend the night, or you posted it right away?
right away, Your Honor.
Well, if I got pulled over and I had $100 bond, I'd have to stay in jail because I usually have about $6 in my wallet. So maybe I should put 100 in there. At any rate, I've showed you pled not guilty. Your lawyer will get the police reports, discuss this matter with the prosecutor. We'll discuss it further at a pretrial conference on Friday morning, October 5th. That's kind of a free-for-all a little bit. We may set 30 or 50 cases all at the same time. The lawyers meet back in the back with the prosecutor and the magistrate in the jury room.
Okay.
So anything you can do ahead of time, discussing the case with the prosecutor, make your life easier.
Okay.
But you're good to go. They'll send you that notice, and you might touch base with the prosecutor to get
I
your.
was planning on touching base this morning.
All right, very good. Nice
Thank
to
you.
meet you. I'll probably see you again.
Yes. Have a great day.
All right. TJ, we had a Rodney Allen Bowman who was a Sturgis case that got set today. Mr. Bowman is charged with driving suspended and failing to yield. Mr. Bowman, why don't you come back up to the podium? He was in an accident. And he and I have met before. He's got a lot of baggage on there, but I didn't know if you'd be willing to dismiss the civil infraction. All right, we'll talk about that. Failing to yield, the way this worked was a civil infraction. Allegation is that you pulled out and were in an accident. That's a $120 fine and 2 points. The city attorney has agreed to dismiss that for a plea to driving suspended. Let's talk about that. As I told you, driving suspended is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. Carries 2 points on your record and requires that you be suspended. Let's take a look at your driving record. Your license is suspended. You've been suspended since 2007 for a bunch of old stuff, including driving suspended and not paying fine. Wow, you go all the way from 2007 to 2025 without having any tickets. But anyway, it is suspended. So he would dismiss the civil infraction, which would save you $120, and I'll give you a fine. But this will continue to go on your driving record and continue your suspension. Do you understand?
Yes, sir.
What do you wish to do?
Plead guilty and pay his fine or whatever.
All right. Do you have your advice of rights?
Yes.
Do you understand by entering this plea, you're giving up all of those rights on the advice of rights there?
Yes, sir.
Anybody threaten you to get you to plead to this?
No, sir.
To promise you anything?
Nope.
Where were you going?
My dog's been out of food for like 3 days. Couldn't get a ride into town to get dog food, so I chanced it myself to go in and get dog food for my dogs.
And you got in a wreck.
Yep.
What to do to your car?
Nothing. We actually didn't really hit each other that hard. No damage to the other vehicle.
Whose car were you driving?
My future daughter-in-law's car.
All right, well, she can get in trouble for letting you drive her car, but that's not before us. Anyway, you've been suspended. You haven't had a ticket in 20 years, as far as I can tell. You need to get, the problem is, well, I'm not sure. This is gonna cause you to be suspended again for at
Yes,
least
sir.
180 days, you understand?
Yeah.
They need to go to the driver's secretary of state and find out what you need to do to get your license.
I already done that, and
What do they need? What do you need to do?
I have a old ticket that I thought was already taken care
Yeah,
of.
over in Coldwater.
Yep, and so I gotta go over there and pay that, and then go through taking the tests and all that.
All right, well, I encourage you to do that, either that or
I
stop
am.
driving.
Because my normal ride is with my father. He was diagnosed with dementia and he's not able to drive no more, so.
Okay, all right, well, the fine is $125. And there's $125 of state cost. The total is $250. Can you pay that by October 1st?
Yes, sir.
And you did not drive here, which I appreciate.
Nope.
You'd be surprised how many people drive to court on a suspended driver's license.
Yeah, I've heard about that.
All right, well, don't do it. All right, stop driving and get your license back, pay that fine, and maybe you're good for another 20 years.
Thank you, sir.
All right, you're good to go. Miss Mo, would you come forward? Good morning. Jennifer K. Mo, or Mao. You say Mao, don't you?
You say no.
Mo? All right. No, I had two choices and I got the wrong pick. Some say Mao and some say Mo. You got charged with no insurance under the insurance code, which is a misdemeanor, punishable by up to a year in jail, and a fine of not less than $200 and not more than $500. You had to fail to have a valid Michigan plate. Normally, that is something that results in a fine. However, you have $1,230 worth of unpaid tickets. 3 of them are no proof of insurance, and 3 more of them are plate violations. We have 1, 2, 3, 4 no proof of insurance, and 4 plate violations. So you keep driving and doing the same thing. Normally, I don't put anybody in jail for this, but for you, I might make an exception. You continue to drive with no insurance and then you don't pay your fines.
I have insurance now.
Well, you didn't, all right,
Is that Poland?
yes,
They're asking for it.
okay. This is,
I'm having difficulties getting my current car legal because my brother died and he was gonna make it legal for me. And
who's your brother?
his biological sister won't give me the title.
There's a bunch of these all in a row.
It's been a very rough year.
Yes. Who is your brother?
Sean Lung.
Sean Long? Okay, I guess I remember that. Well, my advice would be to get a lawyer to help you with this. Keith, would you give her some Kleenexes there?
Oh, yeah.
Tell me to make all the girls cry, but I don't really try to. But this Mo, you keep getting the same ticket and then you don't pay the ticket. And I'm not sure what the prosecutor will do with this. They keep reducing it to a civil infraction. You keep not paying the fine. So they may lose their patience and say, aren't going to do that.
I also just lived the last year on a generator and propane heat. So I was the only one with any type of income, so it was very hard. There was 8 of us at my house and 7 dogs.
8 people and 7 dogs with no heat
No heat, no electricity, no nothing.
on West Street.
Yep. And I was the only one with an income until my brother got his disability and then
Then he passed away. Well, you live in Sturgis. And Sturgis is a little town, and every time they see you drive, they're gonna run your plate and realize you don't have insurance, you're gonna get pulled over again. You don't have $1,300. And if you do, you have better things to do than pay tickets, like buy food and pay for electricity. But you can't keep doing this. I can't wipe those out with a jail sentence. They're civil infractions. However, if you get a misdemeanor, I could put you in jail for up to a year. That's not going to happen, but that's the maximum for this. What happens, people that don't have insurance, they get an accident, they're not covered by the no-fault statute, and they get sued by the other driver's insurance company. A number of times every year, I have uninsured motorists that get a great big lawsuit because they got in an accident, didn't have insurance, and Progressive then sues them for $23,000. And that's even worse. I'm gonna set an attorney pretrial for October 5th. You say you have valid insurance now,
yeah.
plate 2, or you're still working on that?
My appointment is Thursday for the plate.
All right, bring that to your attorney. That may help. All right, I'll have the court officer take you out. I'll put your advice of rights with the file, and we'll get a lawyer. I want you to get proper plate insurance and start to pay on unpaid tickets. All right, I have a number of people. What's your name, sir? Do you have a case or are you just visiting? Do you have a case here this morning? What's your name? All right, well, they didn't write your name down, Mr. Berglund, but come on up here. Let's take care of your matter. This is file number 251658, People versus Kurt Victor Berglund. Can't tell too much about this. The ticket doesn't tell me much of anything. But it's alleged that you failed to use due care and caution regarding an emergency responder.
Yes.
It is alleged that on August 8th at 1:30 in the afternoon at US 131 and Hoffman Road, just by the way, there've been a number of fatal accidents at that intersection over the years. There's a red light there and rumble strips, but there have been a number of bad accidents right there. Apparently there was one that you came upon. So you got a ticket for this. I can't tell anything about what it is that you allegedly did. That's all the ticket says. This is in the city of Three Rivers, but the officer wrote it under state statute. I wish they quit doing that. It is a misdemeanor punishable by up to 90 days in jail and a fine of up to $100. And I believe it carries 2 points. Your options are to plead guilty, or if you plead not guilty, I take zero offense at that. We could see if we could perhaps get a prosecutor to speak with you this morning or set it for a pretrial. What would you like to do?
Plead guilty.
All right, well, tell me what happened.
I had a load of dump stuff. I was headed to the dump, and there was a policeman who pulled over somebody for maybe the same reason, and he left them and came in and pulled me over.
All right, so there, was he pulled off to the side of the road with his lights on?
Yes,
And did you change lanes or slow down?
yes, I did. Yeah, I changed lanes to halfway towards the left lane. I didn't change all the way over.
All right, so you're willing to admit because you didn't get all the way over?
Yes.
All right, let me ask you a couple of questions. Anybody threaten you to get you to plead to this? Promise you anything?
Pardon?
I'll promise you anything?
No.
And you're driving a 2008 Ford pickup?
Yes.
Now, we're upscale down here. We call our dump the landfill.
Okay.
When I was a kid, it was a dump. Now it's a landfill. And we get lots of people coming there and sometimes they get turned over. This was Officer Gavin Rue. Mr. Reed, oh, it's not your case, so you don't have anything. All right, I'll accept your plea. But they take this seriously, and as I indicated, there have been a number of fatal accidents right there at that intersection. What do you do, sir? Retired?
Pardon?
Are you retired?
Yes.
You're a couple of years younger than me, but everybody I meet that's my age is mostly retired. What did you do when you worked?
I was a supervisor at a generating station in Los Angeles. Department of Water and Power.
And you live right in the village of Constant or Schoolcraft?
Yes.
Schoolcraft's a nice little town. All right, it's a $75 fine, $75 crime victims' rights fee. Excuse me, and a $50 state minimum fee. That's $200. Do you wish to just pay that now, or you want me to give an envelope to?
Yes, I'll pay it.
All right, very good. Sometimes the best thing to do is just get it over with. We had this case does get charged from time to time, and they've been taking it more seriously. All right, thank you. Good luck, sir. I'll take you
Thank
out
you.
there. You can pay the fine. All right, we have a number of people that haven't shown up and we'll address those. Rachel Conley, file number 251023. She got picked up on an outstanding warrant. She came into the counter. She wanted to speak to me and take care of this ticket. I was at the judge conference. I told her the judge was out and doesn't take walk-ins. Well, I always take walk-ins. I told her she had a warrant, could not leave. She posted $100 cash bond and set an arraignment. She said she just wait for Judge Pattison to return. He was at a meeting. So anyway, she got arrested, posted bond, set arraignment, 8/26, and now she didn't appear. Now, if I'd have been here, I would have just dealt with her right then, but now she isn't here now. Let's make sure she's not in jail or something. I always take walk-ins. Don't tell them that. Jasmine Conley is in jail, but Rachel Conley is not. We'll try a show cause. This sounds like confusing. Mr. Reed, is it the kind of case that you would take a civil infraction on?
On the families?
Yes.
I'm not sure. I don't have that in one of the reports that I did not have.
Let's take a look, see what I can tell from it. In case she just shows up at a random time. Oh, this was the $46.16. She had a co-defendant, Garcia. She did post $100 bond, I think.
Ryder, did you see the notes reflected that she was arrested after they said she had a warrant?
That's what it looks like. She got arrested on 8/21. I can't tell what happened. I wasn't here. Judge Pattison was. I would have seen her. I'm not sure what he had, the 21st was probably busy because I wasn't here. It was last Thursday. I was driving home from Mackinac Island and riding on a boat. He'll appear, try OSC first. Mr. Reed, is this the type of case per TJR? The city ordinances that allow a civil infraction for disturbing the peace and retail fraud are very helpful. There's no such corollary in a state statute. Property was recovered. Fumble our way through the last couple of these. Sandra Lynn Mosier was a classmate of mine, charged with no valid operator's license. She has this horrible driving record. She owes the court $790 on 3 previous cases of driving without a valid license. And she isn't here. She had some significant health problems, but she isn't here. I'll try a show cause first. Sometimes it works. Mr. Havens showed up this morning. David Zambrano from South Haven. is not here. There was an offer from White Pigeon to reduce that to allowing another violate the motor vehicle code. Defendant failed to appear again. Can do a warrant this time. Bond is $150, cash or surety per file. Some of these are ordinance and some are. He's also got some other stuff under ordinance. 48-hour hold. I've had several conversations with him about appearing and scheduled this date specifically for him. He failed to appear for it. One more. We had no pre-trials this morning, Mr. Reed, which was a blessing. We've had Tuesdays aren't bad. Apparently, we've been doing them on Thursdays, and that's been stressful on the staff. This is Daisy Sanchez Wilson. She never had a driver's license. Had a state ID only. She was local. She failed to appear. Daisy Wilson, I don't have a phone number for you, but you need to get into the court and deal with your no valid operator's license and misdemeanor plate violation. All right, Mr. Reed, that's all I've got. Mr. Stickley, thank you for your help.
That's hard. Thank you.
Thank you. The last several days, we've had several young women with repeated theft problems. And there's a reason for it. And I had a program for it once, but it doesn't exist anymore. I had a difficult one yesterday and a couple of them today. Mr. George is in trial.
Yeah, you're gonna try out my house. Yeah.
And what kind of case was it?
Firearms street case.
Oh, yeah, that's what somebody said. I don't know. Well, he's tried more cases than anybody this last year or so.
I think.
He
this
and
falls
Gary.
under Failed to pay permit fee is what it shows.
Oh, well,
Because if you pay the federal government, you can own your guns.
it's better than the last case he had, which was a terrible fact situation, criminal sexual conduct case. All right, we'll take a recess. Our guests are gonna go out and have a chill bean.
You know what I say about those cases? Better him than me.
Yes, well, you paid your dues. All right, we'll take a recess and we will be on recess because we're gonna have sobriety court and then I'm gonna depart for Kalamazoo. I'll be gone for a little bit. All right, thank you all for saying good morning. And I hope you have a good day wherever you are. I will be busy. Well, who's this? Good morning. My fear is you're in the wrong courtroom and I didn't even know you were there. I'd been working on other stuff and you were in the background. Let's see, I think you're here on a Judge Pattison case. So let me see who we got. Who's your defendant?
Joseph Raymond Sackett, Your Honor.
Yes, that's Judge Pattison's court.
I
Do you
can
have
take care
his?
of that. Your Honor, I'll go look. I'll find the Zoom. I'll take care of that. Thank you.
All right, thank you. I'm sorry, I didn't even have it up. I don't know how long you've been in the waiting room.
Since 8:30, I actually contacted my office to see if they gave me the right information. But
Well, they gave you the wrong information. It's in Judge Pattison's courtroom next door.
Gotcha. Thank you, Your Honor.
All right, thank you.
Have a good morning.
Okay, thank you. He's been sitting there since 8:30 while I've been doing other stuff, but.
Yes, ma'am.
So on the record, in the matter of Paramount Investment LLC versus Lisa Barney, Zachary Barney, 501380. And quote your appearance, please.
Good morning, Your Honor. Simpson Hart, P69542, on behalf of plaintiff.
Thank you. And Rodney Barney, if you can please, please.
Yes, Rodney Varney.
All right. And Lisa Barney, your name for the record, please.
Lisa Varney,
Okay, where's Zachary Barney?
he's at work. He could not, he just got a promotion. He couldn't get off.
Okay, he couldn't zoom in?
No, because
He was just promoted to manager and he opens the business.
Okay, all right, and counsel, you were able to speak with Rodney and Lisa in a breakout room, correct?
That is correct, Your Honor. Thank you for that opportunity. We do have a consent judgment. May I place the terms on the record?
All right, and this consent as to all three or just Lisa and Rodney?
It would only be to Lisa and Rodney, Your Honor.
Okay, and let me just so I just want to confirm before we do all this on the record. On August 15th, defendants had claimed that they had an attorney through legal aid, but that attorney just left. So I granted the request to adjourn to today's date because the defendants stated they were going to seek other counsel. So Ms. Varney and Mr. Varney, are you wanting to proceed without legal counsel?
just for now, yes, because no one ever called us back and we're trying to move at the same time. So it's been rough, to be honest.
Okay. So I just want to make sure you're waiving your right to an attorney.
Yeah. Yes. For now.
I don't know what for now means.
I mean, I'm sorry for this part of it. Yes.
Is there another word?
Well, because of this home that we're in, we found out it had no, it was not registered as a rental. It was never inspected, and it had no certificate of occupancy. And there's lots and lots of things wrong. And our landlord has an LLC, so he definitely knows that he should have done that. And there's so much mold, and we have health problems for it. But we need to really just get out of here first and come back to that when we can.
But if you're raising those issues,
I'm sorry, I couldn't hear you.
If you're raising those issues,
okay,
then because I can't put forth, I can't enter consent judgment because they're making some allegations as to issues. So we'll set this for an in-person hearing.
Oh, okay. I'm really, really trying to find an attorney, and I'm having no luck. I'm none of them have called me or emailed me back. That's where I was just gonna just try to just get out of the home, because we want to get out of the home no matter what. That we planned on that from the get.
Lisa's on bed rest. She is an amputee. So it's really just me, and I'm doing the best I can.
Okay.
Judge, if I may, I did speak with both of the defendants in the breakout room, so thank you for that opportunity. We've agreed to convert this to termination of tenancy, whereby they would be vacating on or before September 5th. All claims and defenses for both sides would be preserved. This is not we were not seeking a money judgment, although it was filed as a non-payment of rent case. It was just for possession only. And I understand from speaking with them that they would like to relinquish possession, and any other claims that either sides have would be sought in a different avenue.
Yes.
If that's what you want to do, you don't want Ms. Varney and you don't want to proceed with an in-person hearing to address the issues that you placed on the record?
I thought that we could come back and do that later. If I'm wrong, please tell me, because
I can tell you that once I enter this judgment, this matter is closed as far as these proceedings. If there's else that either side wants to pursue, then that's a separate action.
Yes. Okay. Yes, we're okay.
Thank you.
And so that's what you want to do, correct?
Correct.
Judge, and for the record, I did advise them of their rights under the court rules, and both Mr. Rodney Varney and Ms. Lisa Varney gave me permission to sign their name to the consent judgment.
Okay. Well, So let me ask then about Mr. Zachary Varney. Is that also being converted to a termination of tenancy?
Yeah, he's fine with it too. I'm absolutely 100%.
The attorney right now. Thank you.
Thank you.
Thank you.
Miss Hart.
Yes, Judge?
Okay, so my question was, is the action being converted to termination of tenancy for Zachary as well?
That is correct.
All right, and so as to defendants 1 and 2, the court does find that the waiver of rights is valid, and they want that they're choosing to proceed without representation, and as to and then the consent judgment will enter. The court will grant the convert. It's a termination. It's converted to termination of tenancy, and all legal claims either side may have are preserved. So, counsel, please make sure that is in the judgment under paragraph 10.
Absolutely, Judge.
And you all agreed September 5th, correct? For the move out date?
That is correct, Judge.
Yes.
All right, the court will note that plaintiff, the parties, defendants not move out on for September 5th. Plaintiff applied for an order evicting the defendants. Additional money may be ordered to damage the property. Person right continues to accrue. Partial payment will not prevent the formation order evicting the defendant. Nobody charged will action at this time. And sports will sign it on the seat.
Thank you, Your Honor.
Thank you. Have a good day.
Thank you. You too.
Okay, and Mr. Mann, is Mr. Fisk here in person?
He should be on his way, Your Honor. He did get screened at the 25th District Court for the sobriety. That's why it took longer. I apologize.
Okay, that's okay.
He hasn't checked in. He said he was on his way.
He's 60.
He's here.
Yes.
Yes. Okay, we're gonna. Okay, let's just. We don't need a sneeze or something.
Well, we have one custody. Moving on.
Okay, Mr. Buckley.
Back.
Well, I think I had to do this Highland Park one, so I think we might have to do.
Can you take a peek at this one?
Welcome back.
Yes.
Yes, this was up on 9:30 one.
Yeah, it's a 2017.
Yeah. She
And
didn't show up.
right.
That's a surprise. Okay, I'll look at that response. Okay, that goes to Charlie. And so Mr. Chunky, you logged back in for which case? You're muted. So if you're talking,
What name, Your Honor? What name, Your Honor?
I'm asking you which name. Who did you log in for?
I'm sorry, for Lydia Grog. I was just still waiting on that 'cause she's in custody.
Oh, yes. Okay. All right. It's gonna be just let me just a little bit on that. The motion hearing I have to do, and so it'll be. Can you log back in at 1:00?
Absolutely, Your Honor.
Okay, let's do that. Let's just that way you don't just bear me.
Okay, thank you, Judge.
Okay, thank you. Okay. Let's go on the record in the matter of Andrew Fisk, 241432.
Stephen Mammon on behalf of the defendant, Your Honor.
Okay, thank you. And Mr. Fisk.
Andrew Fisk.
Sorry?
Andrew Fisk.
All right, very good. Thank you. Okay. And so today's date is scheduled for sentencing on the probation violation that previously been fun to. I know this has been pending for a while. The matter that prompted the violation, there were 2 or 3 issues. One of which was a new case that you were arrested for. That took a little while for that to come to fruition in the 25th District Court. And I believe they were waiting for blood results as well. And the reason this court continued to adjourn it and I'm not sentenced you on it yet was because it was the court's intention to have your sentencing run simultaneously with the 25th District Court in the treatment court, because I would presume that he would be eligible based on my knowledge of the treatment court and your circumstances with both of your cases as well, as specifically in such close proximity. So we had not yet done that, the sentencing, so I just wanted to put that on the record. And it's my understanding, counsel, based upon what you indicated as I checked you in, that your client was screened today for the 25th District Court treatment court.
Yes, he has not. So what I was given the discovery today by the prosecutor. I only adjourned that for a quick week to the next Tuesday, just so I could review and see what we try to get an expedited resolution on this. And then in the same breath, we just discussed with Judge Clifton getting him screened for the sobriety court, which I believe that has been done, or he had the paperwork filled in. Are you, Mr. Prisoner, are you coming back Friday to that court like the judge said, or you did everything today?
No, they said they'd be in contact because I went through the paperwork and the interview process.
Okay, so everything's been submitted, Your Honor. The judge indicated on the record with me present that he suspects he'll be screened on this Friday for the sobriety court, and we plan to be back there on Tuesday for another adjourned free trial. So I have all the discovery. I'm going to review that. We're trying to get everything done as fast as possible, Your Honor. Fast. So I hope to have a resolution next.
So here's my initial thought was that, or the initial intention of the court was that that you would be accepted in the treatment court, and that was going to be the resolution in the 25th District Court. And then this court would then sentence you as a result of your plea on your probation violation to the treatment court. The concern the court has at this point is how much time your client actually has left for supervision in the treatment court.
Obviously, Your Honor, just for ethical purposes, I do owe it to my client to review the discovery in that case.
I'm not suggesting that you're doing anything to delay anything unnecessarily. I'm not suggesting.
Right, and so what my
please let me make a record. Just one moment. Okay. Based upon what you represented, it's not this court. This court does not fault counsel for any of the delay, and I'm putting delay in air quotes, because it took a bit for that to come back from the Wayne County Prosecutor's Office for an authorized warrant. Then I understand that there's blood results that need to be that there are blood results or blood draws, and so then they're awaiting the blood results. So counsel, I'm not suggesting that you're delaying it in any way. The practical the practical issue that this court has to consider is that your client is down to, in this case, your client is down to about 15 or 16 months of supervision left. And on the new matter, he has a fresh 24 months of supervision. So,
right.
So I make that record because I'm inclined to abandon my initial intent and to proceed with sentencing on this matter. I'm inclined to revoke probation, order a 45-day tether, and close this matter out.
I mean, Your Honor, my hope was, like I said, getting the discovery today, getting him screened, and getting that set up and having it. The judge initially wanted to keep it for that September 30th date that we discussed 2 weeks ago that, you had concerns about. We want to get this done on an expedited basis, so we're not dealing with probation problems. Nothing has changed. In fact, we're in a faster trajectory at this point after having gone on the record today. Actually, they didn't even schedule it for today, but they pulled it for me because I explained that you were concerned. So, I think there's nothing that has really changed for the worse since we last spoke. If anything, it's changed for the better. And I think that, you know, everything is going the way it should. I expect, you know, obviously there could be some kind of search issue in this discovery. I just got it, but I expect ultimately some form of resolution in this matter. And I hear what you're saying in this court. I could theoretically exercise some legal arguments on the new case, but may lose the war ultimately with this case, is what I'm hearing. And so, what I want to do is talk with my client about that. If you want to adjourn this to next week after the new hearing, I expect there to be a resolution of some sort. So, I mean, we're very close to having this resolved, Your Honor. In my opinion. I think we're right here. So.
And I hear all, and what I was intending to do in changing this court's trajectory as far as which direction I was inclined to go was just close this out, right? Oh, no longer be on probation, this court, 45 days tether, then everything else that's happening is going to occur the case in the 25th district court and still be screened for the Supreme Court, participating in the treatment court. The concern is if I'm sentencing your client to the treatment court, all right, so let's presume that next week there's a resolution, there's a plea, and then he has a sentencing date. We're still looking at a few more weeks out after that.
I hear you. I see what you're saying.
And so, then what that means then is that now you're down to even one less month of supervision on this case because it no the maximum months or 24 months on a misdemeanor case of supervision. So when I initially was going to sentence your client to treatment care to coincide with this new case in received, right? And then thought occurred to me back in March and April when all of this first transpired. And there was still a significant amount of time left for supervision on this case. But based upon the delays that occurred, not because of counsel, then that's eating up about 7 months of supervision. So that's why counsel, I'm inclined to do 45 days on the alcohol tether, revoke probation on this matter, and then
So you just a scram tether.
The 25th district court case. What's that?
Just you're saying scram tether, alcohol scram tether.
Yes.
Mr. Fisk, what the judge is indicating is that she's going to revoke your probation, not incarcerate you, but put you on an alcohol scram tether for 45 days, so the court can monitor whether you're drinking or not. So no blows.
Currently, right? Like, that's the one you're talking about, the one I'm currently on. Okay.
Yes.
Yeah. Okay. Because when
Well, it's not anything new.
okay, yeah. Because when you said put one on, I was confused. I thought it meant like the home monitoring check. Okay.
Yeah.
Right.
It's not anything new.
If that's the case and there's no incarceration, I'm not going to really object to that. You know.
Right. And then just so you know, in the event the revoked probation comes up in any of your screening discussions with 25th District Court, they can always contact over here and we can explain why it is the revoked your probation and proceed, and then you can proceed with just being sentenced over there for the treatment court.
Yeah,
okay.
Yeah, I have no objection, Your Honor, to that.
Okay, so that's the court's going to do. The court's going to revoke probation. 45 days alcohol and other, which should get you through sentencing anyway over there. Okay. Good luck to you, Mr. Fisk. Good luck to you, Mr. Mammoth.
Thank you, Your Honor.
Your
We're gonna get him on the right track, I assure you, Your Honor.
Yes. Real quick, I have the for my team wellness for the.
oh yes, I'll take a look at that. Is there Thank you. Okay, very good. All right, we'll make a copy of this and we'll keep that in file.
Thank you, Your Honor.
Thank you.
Thank you. You too.
Okay. All right, I'm gonna tell the stop and see,
I'll tell you, so I'm gonna bring it.
okay, thank you very much, okay. All right, so authorization of one split moment. All right, we are on the record, we are recalling the matter of community focused credit union versus John Rushlow, 2320.
Yes, once again, Your Honor, good morning. Michael T. Mamet, P81102 on behalf of plaintiff.
Thank you. And Mr. Rushlow, your name for the record again, please.
My name is John Rushlow.
Okay, and, okay, the two of you, went back to a breakout room to discuss a few more parameters regarding the potential resolution.
Yes, Your Honor, and now I do believe that the defendant would rather argue his motion.
Okay. And so, Mr. Russell, I'm going to have you please raise your right hand. You solemnly swear from the testimony I've given this matter, the truth, the whole truth, and nothing but the truth.
I do.
All right, thank you. Okay, so you filed the motion to set aside the order or set aside the default. The default was entered. That's July 8th of 2025. Okay, Mr. Russell, is that what that says?
Yes.
The judgment was entered July 2025.
Say again, Your Honor?
Sir, you are in court, so if you are having trouble hearing me, then you can let me know that you're having trouble hearing me, but to tell me to say it again is not necessarily appropriate. Mr. Rushlow, was the judgment entered July 8th of this year, so just last month?
Yes, Your Honor.
This is a 2023 case. Oh,
Your Honor,
how?
Your Honor, if I may, it was filed in 2023. The defendant filed bankruptcy. There was an administrative closing. This
Okay.
was included in the bankruptcy. So it was just reopened. Plaintiff filed its motion to reopen and for judgment. The defendant was personally served back in 2023. We received nothing. The motion to reopen was filed in May. Judgment was granted in July. That's where we're at.
Okay, that makes more sense now. Okay.
Thank you.
So, and so the matter was not discharged in bankruptcy?
No, Your Honor, the bankruptcy was dismissed.
Okay. And, Mr. Rushlow, in your motion, affidavit to set aside the default judgment.
Yeah.
Wait a minute. Mr. Manning, so Mr. Rushlow was served in 2023. The order to reopen the case was submitted to this court and then signed on May 9th of 2025. When did you then renotice or re-serve Mr. Rushlow, letting him know this case had been reopened and that you were submitting a default judgment?
Your Honor, I don't believe I have to reserve the defendant with a complaint after the bankruptcy is closed or dismissed in this case. It was included in the bankruptcy. The defendants have been aware of it. The only way you could be aware of it or included in the bankruptcy was if he was aware of it. He was personally served in 2023 and he admits to the debt. So I would argue he has neither good cause nor meritorious defense, but he completely lacks a meritorious defense. So under the two-pronged test, we don't even have to consider good cause.
Well, okay, but let me clarify something. So there seems to be something missed on our end. This matter was reopened after bankruptcy. So what should have happened procedurally is that there should have then been the scheduling order should have been mailed out to both sides. Was that mailed out to both sides?
I didn't receive anything, Your Honor.
Your Honor, I don't know if we got a scheduling order from the court because we had filed our motion and then our judgment.
I understand you filed your motion for entry in default. But what should have happened, because what typically happens when there's both parties that are alleging participation, then there would have been a scheduling order that was sent to both parties, whereby there would have been an order regarding mediation and discovery and whatnot. So that did not happen in this matter.
Your Honor, no answer was filed, so that might be why a scheduling order wasn't sent. I don't know how the court's computer tracks them, but no answer was filed, just the bankruptcy soon after. So that might be why.
GIS doesn't do that. Sorry, I interrupted you. What was that you were finishing saying?
Oh, no, Judge. Again, I don't know how the computer tracks it, because normally if an answer was filed, I could see the scheduling order being sent out, but because no answer was filed, the court or the court's computer, depending on which one you guys use, might have assumed that, you're just moving forward on the default track.
So, Mr. Reslow, you filed a motion to set aside the default. However, you only indicated that number 1A was checked. I don't see what your meritorious defense is. You don't have anything checked for that, nor do you have anything attached to that for that.
Yeah, Charlotte. The only thing I really have is I know the amount that I went bankruptcy for back in 2023 has changed. And I was never given any notice. Talk with the creditor trying to sue me.
Mr.
Just trying to take care of this responsibly. That's why I picked the court for that motion.
Mr. Reslow,
I got to seek legal counsel.
Mr. Reslow,
Yes.
I'm hearing you very difficult. You're standing here.
Yeah, I hear you. Your Honor.
Okay. So I do not see your meritorious defense attached to your motion and affidavit.
Like I said, I didn't know any of this ever existed. I should have sought legal counsel before setting aside this motion. And I will.
Sir, you can't say you didn't know this existed. You included it in your bankruptcy.
I included what in the bankruptcy, Your Honor?
You included this case in your bankruptcy filing. So you can't say you didn't know it existed.
No, I'm not saying that the account, I didn't know what you're talking about needed to be attached to the motion.
Well, did you read the motion and affidavit, sir, before you signed it?
Yes, Your Honor.
Okay. So you have to check either 2A or 2B, meaning whether the court lacks jurisdiction, cause for your failure to appear, and why you didn't appear, and then your defense. You didn't check either one of those, sir.
I didn't know what the meaning was behind those, Your Honor.
Did you contact legal counsel, sir?
I have not done so yet.
Well, okay. I'm not really sure what the delay is, because this matter was filed back in 2023. Did you have an attorney representing your bankruptcy matter?
Yes, I did.
Okay. So then did you speak to your bankruptcy attorney regarding this?
This matter, I was trying to take care of it myself, Your Honor. Being responsible, so I had to go back to the bankruptcy.
Well, here's what this court's going to do. This court will grant you 2 weeks, sir. 2 weeks if you're going to hire an attorney or not. In the meantime, you need to submit your meritorious defense. That's it. If not, this court's going to deny your motion and set aside the default judgment.
Okay, Your Honor.
Your Honor, would the court do that without hearing?
Just a moment. We're going to adjourn this to September 9th. Yeah. 9:30 a.m. Counsel, in regard to no hearing, no, because I want to put it on the record. Okay.
All right. Thank you, Judge. And would Your Honor, if that's not presented, do I have time to file a motion for costs in the interim?
Oh, whatever you want to file, counsel.
All right, thank you, Judge.
All right. Thank you. We'll see you back on the 9th
Thank you.
at 9:30. Thank you. Have a good day.
You as well. Thank you, Judge.
Okay, and then we are on the record in the matter of Cabrini Catholic School for Kayla Valley, 2501104.
Good morning again, Your Honor. Simpson Hart, P69542 on behalf of plaintiff.
Thank you. And Miss Valley, your name for the record, please. You're muted. I need you to unmute, please.
Kayla Valley.
Okay, and counsel, the two of you were able to speak in a breakout room, correct?
Yes, that is correct. Thank you for that opportunity, Your Honor. However, we were not able to resolve this. We did not get attachments to her motion to set aside the default judgment, indicating the reason why she failed to appear or the meritorious defense or an affidavit or any other documentary evidence as to a defense to this action. So I'd ask that that motion to set aside the default judgment be denied.
Ma'am, please raise your right hand. Do you solemnly swear from testimony about giving this the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, so a couple things here. All right. The default was filed July 24th. And Ms. Valley filed her motion to set aside default on August 1st. And so, ma'am, did you receive notice of the complaint?
So I received a letter in the mail about the judgment, and it said that I had a certain amount of days to answer back to them or to appeal. So I had called their office to see what I needed to do, what my options were, because I wanted to appeal it because my son only went to school for maybe a total of 15 days, which I did.
Hold on. That you're getting into the facts of the case. Right now I'm asking, were you served a copy of the complaint in this matter? Complaint, not default judgment, complaint.
Yes. And I responded to the lawyers, and I made the mistake of not also sending it to the court. I had only mailed it to them, and I made that mistake. I didn't know that I was also supposed to mail it to the courts and as well to their lawyer's office. So that was my mistake.
Just a moment. You filed an answer?
Yes.
Ms. Hart, do you show that there was an answer filed?
No, Judge, we haven't received an answer from Ms. Valley.
Did you receive any communication from Ms. Valley after service of the complaint?
No, Judge.
Not at all.
Not at all. I'm looking at her case file now, Judge, and we did effectuate personal service on Ms. Valley with the summons and complaint. She has not answered that. We haven't received anything.
Okay. Mayor, did you receive something personally from a processor regarding the complaint?
I'm sorry, what did you say? You're kind of breaking up.
Did you receive something personally served to you about the complaint?
I did receive, after I sent the appeal, I got served with the judgment being signed by the judge. That was the last thing that I received.
That's not your question. So when the case started, it's called a complaint.
Yeah.
That was on June 19th. When did you find out about this entire case, ma'am?
It was in the beginning of July. It was the first week of July that I mailed out when I talked to the office, and she told me that I had to respond within 20 something days.
Okay.
So I believe. Yeah, I do. And I also submitted it to you guys too. When I did the motion to default, I also provided my answer with that as well. And all the medical documentation was included in that, as well as what I sent to the Andrew Cox law office.
Well, I'm seeing that there's, I'm seeing medical stuff here. Let me see here. Okay, so I'm seeing 22 pages. Is that what you're talking about, Mia?
Yes.
Okay, and Miss Hart?
We did not receive a copy of that, Judge. We just have a copy of the motion. And I believe her statement was that she didn't file an answer until after she was defaulted. So
she, ma'am, counsel, her statement was that she sent it to the attorney's office. So I'm wanting to know, where is that?
we don't have it, Judge. Anything that is sent to us is scanned and placed in a file. We don't have anything from Miss Valley.
Miss Valley, how did you send it to the attorney's office?
By mail. It was to this address. I don't, it was on the other form. I have it at my house. I could get that address, but it was through the Andrew Cox, I think it was. So when I got served initially for the judgment and called the office, and I also requested to make an appointment with Andrew as well. And then I never heard anything back. I never heard anything back on my response to them. And then when I got the default, that's all I received. I had contacted my lawyer and asked him what I needed to do because I clearly had made a mistake wrong. He was like, you need to file that with the court as well as mailing your answer to them. You have to mail your answer to the courts. And I did not do that, which that is my mistake. I've never really been in this situation before, so I didn't know how to do that. But I mailed it to them.
All right. Well, Miss Valley filed it within 14 days, so that time frame is clearly complied with. We're going to have an in-person hearing, so I want to see all the documents that there are, when those were sent, all of that. And a call out or whatever you have that says that contact the attorney's office and all of that stuff. So,
which I can also probably pull that up on my phone records. Would you like me to do that as well?
Absolutely. Okay. Anything that's going to assist me in making my decision.
Yes, Your Honor.
We will get this for an in-person hearing on September 9th at 2 p.m. Does that work for you both?
Yes, Judge.
May I just check my son's appointments really quick? We are at the hospital very often. Just 1 second, I can check. That works for me.
Okay, very good. We'll see you all in person September 9th at 2 p.m. Ma'am, anything that you are intending to submit as evidence to the court, you need to send to the other side.
Okay, so anything that I submit also to you guys, I have to mail it to them as well further? Okay, thank you.
Okay. All right, anything else, counsel?
No, nothing for plaintiff, Your Honor. Thank you.
Thank you. Anything else, Ma'am? Ms. Bailey, anything
Nope, that's
else?
all. Nope, that's all. Thank you.
All right, have a good day. So, awesome.
Thank you, Your Honor. I believe that concludes it for the Cox docket. Have a great day.
You too.
Thank you.
Okay. And so we are on the record in the matter of Highland Park case number, the 30th District Court number 25536. The name of Highland Park versus Carla Oliver. And appearance for the people, please.
Oh, for City of Highland Park, Tillman, with safety 81003. I am the
May we all first judge my Clinton?
Yes, that's right here. Yeah. Okay. All right. I'm sorry, Pastor. Your appearance again, please.
Tillman, with safety 81003 on behalf of City of Highland Park.
Thank you.
May it please the Honorable Court, Gilbert Borman, P37642.
All right. Thank you. And your name, please.
Carla Oliver.
Okay. Just make sure your hands are out of your pockets, please. And it's today's the date scheduled for the motion hearing. And counsel, Mr. Borman, you filed a motion to dismiss, correct?
Yeah.
All right, and people filed a response.
They did.
All right, and are we proceeding with the motion hearing?
Yes, if you please, Judge.
Okay, and so council, you may proceed.
Judge, now is the date and time set by the Honorable Court for its hearing. And it's our contention, and our brief is very clear, just to hit a couple of high points on it in terms of what it has to say. First off, if my client had really committed a breach of the peace on that day, the chief of police of Highland Park was right there. She wasn't arrested. Secondly, and there's a problem with evidence on this in that we do not have any video from the hallway where everything took place. To refresh the court's memory, the actual confrontation between my client and the mayor started. My client was standing in the hallway. The mayor was in a room, and immediately at the end of that hallway, and the mayor had directed my client to appear and was proceeding to abuse my client, knowing that she was in the hallway, knowing that she could hear her all so clearly. And on at least 5, probably 8 or 9 occasions, said she's suspended, no pay, she's suspended, no pay. She kept saying it, knowing that my client was there. Quite honestly, the mayor instigated the incident, and this can be shown. Secondly, and probably just as importantly, the incident happened on December 20th, 2024, but the case wasn't even filed until April 2023. The court should ask, why did it take so long? And that gets to our main concern with this particular case, is that it is politically motivated. That this was done at the behest of the judge by the leader of the city, because she wasn't happy with my client. And I would also add that my client had made a number of comments about city government in the couple of weeks preceding the handing down of the case. And there can be no question that this case it should never have begun. And the city knew or should have known better, and they filed it, and here we are. And it's not fair to my client, obviously, to be facing charges. And on top of that, they accused her of a battery. Yet even by any of their own discovery, they admit that there was no physical conduct. So why was she charged with battery too? Again, it goes to the political motivation to harass and intimidate somebody, questioned how the mayor was leading the city, which gets us to where we are today. A judge sitting in hearing, completely independent of what the events, and we're presenting you a picture that should cry out to the court saying, this can't happen. This isn't how we govern in this country. And I think that's pretty much it. There was no breach of peace. If there was a breach of peace, it was instigated by the mayor. She absolutely knew my client was in her voice shot. She demanded that my client be there. And so she was harassing and intimidating my client. And finally, when my client couldn't stand it anymore, she walked into the room and said, back off, and then immediately backed off. Well, then the mayor became the aggressor, and she took steps towards my client, and my client was the one who was forced to step back. Judge, if you have any questions, we're happy to answer them. Thank you.
Okay, so I do have a quick question. And so I just wanted some clarification, because I thought you stated that it was at the behest of the judge.
I'm sorry, not the mayor, not the judge.
The mayor. Okay.
If I said the judge, that was a incorrect.
You also said it was filed in 2023. So it's
I'm sorry, it was April 23rd, 2025.
Oh, okay. All right. And then the offense occurred April 24.
Right. It's December 2024.
December 24. And so, counsel, your position is that there's not even a trial issue of fact.
That there can't be any question of it. And if it ever came to it, the court would inescapably reach the conclusion that the mayor was the aggressor and provoked the incident.
Okay, thank you very much. Yeah, prosecutor, I'll give convenience. And thoughts.
Thank you, Judge.
Thank you.
Good morning, Your Honor.
Good morning.
At the outset of the case, defense counsel's exact argument is why this case needs to go to trial. Everything he stated is an issue of fact. He states that one person started over the next person, or who was the aggressor or not the aggressor. Those are the exact issues that needs to go to trial to be decided. To his argument of this case, there was no battery. We all know, going to law school, you learn that assault and or assault battery comes together in the Michigan statute. The statute says that it's either an assault or an assault and battery. There does not have to be a battery to have an assault. We know that. That's clear by case law. That's clear by the statute that an assault can occur without a physical touching. So the whole argument of there was no battery, so this case can't be a real case, doesn't matter because an assault did occur. And if he's saying that an assault did not occur, again, that is an issue that needs to go to the trier of fact to determine whether an assault actually occurred or not. If this argument that defense counsel was making was a valid argument, everyone would get off on crimes. You could just file a motion to dismiss and say, hey, this is not valid. It should not go to trial. Trial is the reason for this to determine if Ms. Oliver is guilty of this or not. Now, his arguments about political retaliation and all of that, that has nothing to do with the charge of assault and battery of juror, which is what we are here today in court for. That's all I stand on my response to everything else.
Okay, thank you, counsel. One question I have is regarding this incident occurring December 20th and charges weren't brought until April of 25. Can you speak to that, please?
So I don't know what took so long. I know once it hit my desk, I reviewed it and it was signed immediately. The police department had to think their own way. I don't know if they were doing an investigation. They maybe had to get some witness statements. I can't speak to what happened before the actual warrant hit my desk and it was signed off on. But we all know sometimes cases do take a while to be filed. The police has to do their job. They have to investigate, speak to people, do whatever they have to do before it gets to the prosecutor to be signed off on. But I do know there was no delay between once the warrant hit my desk and the sign.
Well, I'm not suggesting that. I was just wondering, and the point of my question was to determine whether or not there was the delay between December and April because of investigation or witness statements, just as you've indicated. I was just wanting to know why the delay.
That would obviously be my assumption that maybe they were trying to investigate or get statements beforehand.
All right. So this shows the date of the warrant request is Thursday, March 20th, 2025. Then when was the date that the warrant was authorized?
I don't want the exact date. I don't have it offhand. All of mine are in the office, of course, but it may have been the April date. Let me double check. I remember getting that email from the detective. Didn't know it bought it. Did you know it bought a copy? I don't have that information in front of me. I'm sorry.
Okay. The court will note that there is an investigative summary dated February 7th of 25, which would further support Madam Prosecutor's statement that there was likely an investigation that was going on. There were statements further gathered on February 14th of 2025.
What was the April date that she just stated, Charles?
April 23rd. So I will say that it does look like it was authorized by Madam Prosecutor April 23rd, and then sworn to by Judge Officer Holly on April 23rd as well. All right, so counsel, so Mr. Foreman, I don't find there's a reasonable delay in the filing of the complaint warrant.
Judge, if I may,
Okay.
if I might rebut just one thing that I think it's very, I really want to stress this point. Judge, the chief of police of Highland Park was present at the incident. If he felt he was not,
Ma'am, I can't.
I'm sorry, I thought he was.
Well, this just shows why why it would have to be, there's a question of fact. There's a question of credibility, all of which this court is not to decide at this point. There were charges that were filed, and the issues that you raised, counsel, are questions of fact, questions of credibility of witnesses, all of which is to be done by the trier of fact, which I believe there was already a request for a jury trial, and there was some statement there was going to be a jury trial.
True, but Judge, this took place in the City Hall of Highland Park, which is also, I believe, the police are in that office as well. If there had been a real breach of the peace, the police would have been summoned immediately. Immediately. That's what didn't happen. And I think that speaks to the lack of fear on behalf of the complaining witness, the mayor. And I don't think they can overcome that. They'll never overcome that.
Well, counsel, that sounds like that's the start of your opening and closing arguments for trial. However, that is not something that this court is to make a ruling on at this point. It's a factual issue. It's an issue for the trier of fact. There's not a legal issue that is before this court. So, as such, the court has to deny the motion to dismiss, and we'll set this for trial.
Very good. Thank you, Judge.
So, that's going to look like a disaster for the doctors anyway, because I didn't go here. So, I need to confirm with further district boys days they have available. So, let's. Okay, Ms. Wilkerson, are there certain days that are your Highland Park prosecution days?
Our criminal misdemeanor docket is Wednesdays, but if we have a jury trial from that docket, is normally set on a Thursday. We don't do the jury trials on Wednesdays because we have a regular docket, so it'll be set on a Thursday.
Well, I'm going to see what Andy said on a Tuesday because I have my state docket on Thursday. Can you do Tuesdays?
I don't think it's necessarily me. I don't know. We have a different docket on Tuesday. So,
I understand.
But here's the thing, though. It should not matter, Your Honor, if you are presiding over the case because, we should be able to do this. Yeah, because the building that we operate out of would not be the building that the jury trial would be held in. So we could have the jury trial at that other building.
Where's the jury trial held?
At the City Hall building, but we don't operate out of that building. We have a different building where we hold court from. But where we are stationed.
So there's going to be a lot of logistics turning.
Yes. Maybe, yes.
Okay.
But I'm sure if you choose a Tuesday, they should be able to make that work, I think.
Okay. The Tuesdays work for you, Nelson?
It depends on the Tuesday, but I would assume we'd be talking about some date out in either late September, early October.
Absolutely, because my September dockets are absolutely full. So we're talking early October, but
I would actually prefer mid-October if you don't mind, Judge, just because I've got a couple of things that I know is in early October, and I'd rather have this just fall after that.
Well, if it works that way, then possibly. So I'm looking at October 14th. Does that work for both of you?
Give me 1 second, which should be fine.
Hopefully right on, it looks clear for me.
We typically do jury selection the afternoon prior day, but we'll just pick and go that day and do it right at 8:30.
That day will work, Judge.
Will work?
Will work.
Okay. So, and just so you're all aware, since we're just doing it in one day, if it goes past typical, traditional court hours, just gonna stick through and continue on. Typically that's what the jurors prefer anyway, so they don't have to come back another day. But that way we can just don't have to worry about cleaning up another day or otherwise. Okay, so I'm going to have all of you have a seat out in the lobby for a few moments. I'm going to have my court administrator reach out to the district court to confirm that date works for them. And Great Hall also.
I really need to get out of here. I did not know this was gonna take this long, and I'm like 40 minutes away from my next destination. I have to be there at 1:30.
Okay.
Just do it by mail, Judge?
Well, we have your email, correct? Okay, so for right now, we're just gonna stick with October 14th. If there's an issue, then we will communicate with everybody. But I will also indicate this, that witness and exhibit lists are due by September 19th, and criminal and proposed jury instructions and then we will do a final conference. That way, what I do is be confirmed to see if there's any issues with any witnesses, any of the exhibits, any of the proposed jury instructions, and then we have all that finalized so that on the day of trial, we don't have to utilize any of that time and we just go. Okay. So we will do the final conference on September 23rd. At 11 a.m.
That may not be a good date for me, Judge. Just hang on a second, please.
That day wouldn't be good for me unless we do it like later in the morning.
The 23rd doesn't work. I'm out the 22nd.
Hold on, Council. Hold on, Council. She was still speaking.
It's fine. I wasn't saying it doesn't work.
So that you said later in the morning?
Like if you push it later in the morning, 10:30, 11 maybe, but before then I can't.
Okay.
Could we do the 25th?
We can do the 25th.
That would work for me. The rest of the week is just I've got conflicts.
The 25th work for you, Council?
It would be the morning, 25th.
We could do 1 o'clock. We could do it in the afternoon.
Yeah, I'm bored.
Okay, let's do that. Let's do the 20th. Does that work for us, Aaron?
Yes. And it's for
final conference and call it. So your client doesn't be present, Council, unless there's a resolution that's going down the record. Your client doesn't have to be present.
I have a question.
Stand up when you're dressing.
Sorry, I've never been in court before like this. In regards to the bond that I have, right? And I read the letter and it says no contact, which I haven't contacted her. I don't need to contact her. I just want to make sure because I am very vocal on our Highland Park social media. I want to make this clear about this court and this situation that's happened on that page. I want to make sure the whole city is there.
Is that where?
In court that day. So I want to make sure that it's not considered intimidation at all. That's what I'm asking. I want to be able to vocally state about what's going on.
Let me state this. Let me say that the courtroom is open to everyone.
Okay.
And I also operate a courtroom that is going to maintain decorum and respect.
Mm-hmm. I'm sorry.
So if any of that is being violated, that will be dealt with on that day. There has not been a motion to close the courtroom. There's not been a motion to exclude anybody. So as your attorney will indicate, the courtroom is open to the public. That's where we stand right now.
So I can post.
You still have your first movement, right?
Okay. That's it. That's all.
As long as you're not violating bond conditions.
Yeah. I just want to be clear what intimidation actually meant as far as that's it.
Case is allowed. That's not.
Oh, okay. That's what I want to be sure of. That's all.
Okay, did your attorney clarify that? Was
Yes, yes, Your Honor.
Okay,
Thank you, Judge.
all right. Anything else?
Nothing further, Your Honor.
Okay, fine, we can just start continue and we will go off the record. All right, in the meantime, I'm going to have my staff work with county district court staff to figure out all the logistics work for a jury trial in the city. For the jury box and everything, the city hall.
Well, that's the original courthouse in City Hall, but we're will sort of transition it into a new building, so that's why we're not at the City Hall.
Okay, that
But
makes
it's
more
still
sense.
comparable as the courthouse.
Oh,
Will that, the trial is held there?
Yes, it's normally held at the original courthouse when we have jury trials. Yes.
Okay, but our judge is 17 of course.
Yes.
okay.
Fine. And,
How many court officers, I'm sorry, how many court officers does the one is? We're thinking about the future. Right,
thank you, Judge.
right. Thank you. Great.